हेलो दोस्तों, स्वागत है आपका हमारे चैनल प्रो लॉ शिक्षा में। आज के इस वीडियो में हम लेके आए हैं 50 मस्ट सॉल्व एमसीक्यूज जो बहुत ज़रूरी हैं कोई भी कॉमन लॉ एंट्रेंस टेस्ट्स के लिए, जुडिशरी प्रीलिम्स या मेंस के लिए, एलएलबी और बीए एलएलबी कोर्सेज के लिए या फिर मास्टर्स इन लॉ के लिए। ये क्वेश्चंस आपके लीगल कंसेप्ट्स, करंट अफेयर्स और प्रैक्टिकल सिनेरियोज को समझने में मदद करेंगे। तो अपना नोटबुक ले लो, वीडियो के एंड तक ज़रूर देखो और अपने लीगल जर्नी को एक नए उड़ान दो। डोंट फॉरगेट टू लाइक एंड सब्सक्राइब। तो हमारा पहला क्वेश्चन है, अ मुस्लिम गोज टू एनी कंट्री ऑफ द वर्ल्ड विथ हिज पर्सनल लॉ, B. without his personal law, C. leaving his personal law in his country, D. with an object of obeying the laws of the country concerned which includes personal law. And इसका आंसर है D. with an object of obeying the laws of the country concerned which includes personal law. So अगर कोई मुस्लिम अपनी कंट्री छोड़ के दुनिया की कोई भी कंट्री में जाएगा तो वो उस कंट्री के लॉज भी ओबे करेगा एंड अपने पर्सनल लॉ को भी ओबे करेगा। ही विल बी ओबेइंग बोथ द लॉज। वेयर अ मुस्लिम मेल एंड अ मुस्लिम फीमेल कॉन्ट्रैक्ट देयर मैरिज अंडर द स्पेशल मैरिज एक्ट 1954 मुस्लिम पर्सनल लॉ, ए अप्लाइज टू सच मैरिज, डज नॉट अप्लाई, सी अप्लाइज विद सम मॉडिफिकेशंस, D applies with Indian Contract Act. और इसका आंसर है B. does not apply. That means अगर कोई भी मुस्लिम रिलीजन के मेल और फीमेल स्पेशल मैरिज एक्ट के अंडर अपनी मैरिज कॉन्ट्रैक्ट करते हैं तो फिर उन्हें मुस्लिम पर्सनल लॉ अप्लाई नहीं होगा। थर्ड क्वेश्चन इज, अंडर द शिया लॉ, if the husband has capacity to speak but announces talaq in writing, the talaq is C. void. क्योंकि according to Shia school of Muslims, divorce जो तलाक भी कहते हैं must be pronounced orally, मतलब सिर्फ अरेबिक वर्ड्स में ही जब हस्बैंड वाइफ को तलाक बोलेगा तभी ही डिवोर्स माना जाएगा। बट सुन्नी लॉ में तलाक बोल के भी दे सकते हैं और राइटिंग में भी दे सकते हैं। पर अपना क्वेश्चन यहाँ पे क्या कहता है, वेयर इन शिया लॉ अगर हस्बैंड बोल सकता है बट फिर भी वो बिना बोले राइटिंग में तलाक दे रहा है तो ये शिया लॉ के स्कूल के रूल्स के खिलाफ है, इसलिए ये तलाक वॉइड माना जाएगा। फोर्थ क्वेश्चन है, अंडर मुस्लिम लॉ मैरिज इज रिगार्डेड एज ए सेक्रामेंट, बी कॉन्ट्रैक्ट, सी सोशल नीड, डी ट्रेडिशन। इसका आंसर है बी, बिकॉज मैरिज अंडर मुस्लिम लॉ इज़ नॉट अ सेक्रामेंट एट ऑल। वो प्योरली एक सिविल कॉन्ट्रैक्ट माना जाता है। जैसे हर एक कॉन्ट्रैक्ट में एक ऑब्जेक्ट रहता है फुलफ़िल करने को जिसकी वजह से वो कॉन्ट्रैक्ट दोनों पार्टीज़ में बाइंडिंग रहता है, वैसे ही मुस्लिम लॉ के अंडर मैरिज का एक ही ऑब्जेक्ट है, दैट इज़ प्रोक्रिएशन ऑफ चिल्ड्रन। सो दैट इज़ वाई दे कंसिडर मैरिज एज अ सिविल कॉन्ट्रैक्ट। फिफ्थ क्वेश्चन है, द एसेंशियल कंडीशन of a gift under Muslim law is A. declaration of the gift by the donor, B. acceptance of the gift by the donee, C. delivery of possession of subject matter of the gift, D. all of the above. And इसका आंसर है D. all of the above. The reason is according to the Muslim law, the essentials of gifts are Number 1, declaration of the gift by the donor, that is called ijab in Muslim law. Like donor जब भी गिफ्ट देगा तो वो सबके सामने पहले डिक्लेयर करेगा। सेकेंड रहेगा एक्सेप्टेंस ऑफ द गिफ्ट बाय द डोनी, दैट इज़ कॉल्ड कबूल. सो जो जिसको गिफ्ट दी जाएगी वो अपना एक्सेप्टेंस भी उस पर देगा. एंड तीसरा रहेगा कब्ज़ा, दैट इज़ डिलीवरी ऑफ पोजेशन. जिसने गिफ्ट दूसरे को दिया है, जब दूसरे के पास वो गिफ्ट की पोजेशन आ जाएगी तब जाके टोटल इसेंशियल्स ऑफ गिफ्ट अंडर मुस्लिम लॉ कंप्लीट होते हैं. नेक्स्ट क्वेश्चन इज वक्फ कैन बी मेड बाय A. A Muslim only, B. A Hindu only, C. Both Hindu and Muslim, D. Neither by Hindu nor by Muslim. इसका आंसर है A. The word A, that is a Muslim only, because the word waqf itself explains it. Waqf literally means detention. So according to section 2 of the Mussalman Waqf Validating Act 1913, Waqf means the permanent dedication by a person professing the Mussalman faith of any property for any purpose recognized by the Mussalman law as religious, pious or charitable. So, this means a Waqf cannot be made by any other religion person. Our next question is Hanuman Prasad versus Musammat Bibi is a case on A. Powers of Karta of Hindu joint family. Second, Avyaya Vaharik debt. C. Power of adoption of a widow. D. None of the above. And the answer is A. Powers of Karta of the Hindu joint family. जो हिंदू जॉइंट फैमिली में जो मेन हेड रहता है, जिसको हम लोग बोलते हैं ना हिंदी मूवीज़ में, हिंदी बॉलीवुड मूवीज़ में, करता धरता आप ही हो. सो द मेन हेड, तो वो केस टोटली करता ऑफ द फैमिली. नेक्स्ट क्वेश्चन इज which section of Hindu Marriage Act 1955 provides for conditions of marriage? A. Section 5, B. Section 9, C. Section 10, or is it D. Section 11? The answer is A. Section 5. Section 5 of Hindu Marriage Act provides the condition for a Hindu marriage in which a marriage can be solemnized. Next question is, in which section of Hindu Succession Act 1956 general rule of succession in the case of female Hindus is provided? A. Section 15, B. Section 14, C. Section 18, or D. Section 16? The correct answer is A. Section 15. Section 15 of Hindu Succession Act 1956 provides the general rule of succession in the case of female Hindus. फीमेल हिंदूज़ के जितने भी सक्सेशन के रूल्स है वो सेक्शन 15 ऑफ हिंदू सक्सेशन एक्ट में प्रोवाइडेड है. और द प्रॉपर्टी ऑफ फीमेल हिंदू डाइंग इंटेस्टेड शैल डिवॉल्व अकॉर्डिंग टू द रूल्स सेट्स आउट इन सेक्शन 16. सो अगर कोई फीमेल हिंदू जो इंटेस्टेड डाई हो जाएगी, मर जाएगी, उसकी जो प्रॉपर्टी है उसको डील करने का जो रूल्स है वो सेक्शन 16 में दिया हुआ है ऑफ द हिंदू सक्सेशन एक्ट. नेक्स्ट क्वेश्चन इज द हिंदू मैरिज एक्ट 1955 केम इनटू फोर्स ऑन A. 1st January 1955, B. 1st May 1955, C. 26th January 1955, D. 18th May 1955. The answer is D. 18th May 1955. Next question is Dastane versus Dastane is a case on A. Adoption, B. Divorce, C. Marriage, D. Maintenance. The correct answer is B. Divorce. In this case, सुप्रीम कोर्ट ने एक्सेप्ट किया था the contention of the petitioner that he was subjected to inexcusable cruelty by his wife. So यहाँ पे सुप्रीम कोर्ट ने खुद एक्सेप्ट की थी कि जो कंटेंडर है, जो कंटेंशन है पेटिशनर की, कि उसको बहुत ज़्यादा क्रूअलिटी से उसकी वाइफ ने रिलेशन में रखा था, and the contents of cruelty was sufficient to establish a case of judicial separation. Because of this, judicial separation भी grant किया गया था. Next question is, which one of the following is the correct statement? A. Divorce by mutual consent has been provided under the Hindu Marriage Act from its inception. B. Divorce by mutual consent was introduced by Hindu Marriage Amendment Act 1976. C. Divorce by mutual consent has been provided under Section 13A of the Hindu Marriage Act. D. A petition for divorce by mutual consent must be presented within 1 year of a marriage. The correct answer is B. Divorce by mutual consent was introduced by Hindu Marriage Amendment Act 1976. Next question is, match list 1 and list 2 and select the correct answer using the code given below the lists. List 1. A. Marriage between parties within degrees prohibited relationship. B. Impotency. C. Marriage between two sapindas of each other. D. Pregnancy of wife at the time of marriage by some person other than the petitioner. List 2. 1. Voidable. 2. Void. 3. Voidable. 4th. Void. And answer is A. Marriage between parties within degrees of prohibited relationships is void under Section 11. Impotency is the ground of voidable marriage under Section 21, subsection 1, clause A. Marriage between two sapindas of each other is void under Section 11. Pregnancy of wife at the time of marriage by some person other than the petitioner is voidable under Section 12, subsection 1, clause D. Next question is assertion A. A bigamous marriage is void under Hindu law. Reason: a child born out of void marriage is legitimate child of his parents. Choose the correct answer by using the code given below. Code: A. Both A and R are true and R is the correct explanation of A. B. Both A and R are true but R is not the correct explanation of A. C. A is true but R is false. And D. A is false but R is true. And the correct answer is B. Both assertion and reason are true, but reason is not the correct explanation of assertion. Next question. Assertion: extrajudicial confession, if voluntary, can be relied upon with other evidence. Reason: extrajudicial confession is a weak piece of evidence. Code: A. Both A and R are true and R is the correct explanation of A. B. Both A and R are true but R is not the correct explanation of A. C. A is true but R is false. And D. A is false but R is true. And the correct answer is A. Under Section 24 of Evidence Act, it takes about the extrajudicial confession and its evidentiary value. So that means both A and R are true and the reason is the correct explanation of assertion. Next question. Which one of the following sections of Evidence Act defines admission? A. Section 16, B. Section 17, C. Section 20, D. None of these. And the answer is B. Admission is defined in Section 17 of Evidence Act. Next question. Which one of the following does not find a mention as showing state of mind under Section 14 of Evidence Act? A. Intention, B. Knowledge, C. Motive, D. Good faith. And the answer is Section 14 talks about intention, and the answer is C, that is Section 14 talks about intention, knowledge, good faith, negligence, rashness, ill will or goodwill toward any particular person. Next question is, which one of the following is not essential condition for admissibility of dying declaration? A. Death of the person making dying declaration. B. Statement must be as the cause of his death. C. Person making statement was under expectation of a death at the time he made the statement. D. Statement is as to any of the circumstances of the transaction which resulted into his death. And the answer is C. Expectation of death at the time he made the statement may be a condition of dying declaration under Section 32 of IE Act, but it is not an essential condition. Under which of the following provisions of the Evidence Act the word forming part of the same transaction occurs? A. Under Section 5, B. Under Section 6, C. Under Section 7, or is it D. Under Section 8? And the correct answer is B. Section 6 of Indian Evidence Act provides the relevancy of facts forming part of a same transaction. Next question. A's death is caused due to negligent driving of B. In the word forming part of the same transaction occurs A. The fact that A was a young man of 30 years. B. The fact that A was a young man with good physique. C. The fact that A had qualified in PCSJ. D. The fact that B was in the habit of driving negligently. And the correct answer is D. Section 14 of Indian Evidence Act relates to the fact that B was in the habit of driving negligently. Next question. The provision relating to estoppel is contained in the Evidence Act in Section 115, B. Section 117, C. Section 118, D. Section 114. And the correct answer is A. Section 115. Next question is, presumption as to abetment to commit suicide by a married woman has been given A. Under Section 114 of Evidence Act. B. Under Section 113A of Evidence Act. C. Under Section 113B of Evidence Act. D. Under Section 112 of Evidence Act. And the correct answer is B. Presumption as to abetment to commit suicide by a married woman has been given under Section 113A of Evidence Act. Next question. Which one of the following is not a public document? A. An unregistered family settlement. B. A registered sale deed. C. Judgment of a high court. D. Judgment of a civil judge. And the correct answer is A. That is given in Section 74 of the Bare Act of Indian Evidence Act, which shows that an unregistered family settlement is not a public document. Next question. Which section of Indian Evidence Act is based on the maxim Salus Populi est suprema lex? A. Section 119, B. Section 120, C. Section 115 and D. Section 123. And the correct answer is D. That is Section 123. This maxim means that regard for public welfare is the highest law, is the basis of the provision contained in Section 123. This was also relevant in case in Raj Narayan versus Smith Indira Gandhi. Next question. A fact neither proved nor disapproved is known as A. Proved, B. Disapproved, C. Not proved, D. Conclusive proof. And the answer is C. Not proved, because it is defined under Section 3 of Indian Evidence Act, which says that the fact is said not proved when it is neither proved or nor disapproved. Next question is, in the case of Pakala Narayan Swamy versus Emperor, it relates to A. Doctrine of estoppel, B. Dying declaration, C. Accomplice, D. Cross-examination. And the correct answer is B. The case is related to dying declaration. Next question is, match list 1 and list 2 and select the correct answer using the code given below the list. List 1 is relevancy of facts. A. Facts as effect of facts in issue. B. Facts forming part of same transaction. C. Facts which constitute preparation for any fact in issue. D. Facts necessary to explain or introduce relevant facts. List 2 is a section of Evidence Acts. Number 1 is Section 9, 2 is Section 8, 3 is Section 7 and 4 is Section 6. And the correct answer is C. Code C. Next question. Which one of the following provisions of the Evidence Act provides that previous bad character of an accused is not relevant? A. Section 54, B. Section 52, C. Section 53 and D. Section 118. And the correct answer is A. Section 54 of Indian Evidence Act clearly explains that the previous bad character is not relevant except in a reply. Next question. Which of the following section of Evidence Act says that confession caused by inducement, threat or promise is irrelevant? A. Section 25, B. Section 26, C. Section 27 or is it D. None of these? And the correct answer is D. Section 24 of Evidence Act explains that confession caused by inducement, threat or promise is irrelevant in criminal proceedings. So if कोई भी person किसी को कुछ धमका के, कोई झूठे promises करवा के या किसी भी चीटिंग वे में कोई कन्फेशन करा रहा है कोई क्रिमिनल केस में, तो वो कन्फेशन अंडर सेक्शन 24 इररेलेवेंट माना जाएगा. नेक्स्ट क्वेश्चन. In which of the following cases it was held that Section 27 of the Evidence Act is an exception to Section 24, 25 and 26? A. Pakala Narayan Swamy versus Kind Emperor, B. Inayatullah versus State of Maharashtra, C. State of UP versus Diyoman Upadhyay, D. Kotyaya versus King Emperor. And the correct answer is D. Kotyaya versus King Emperor केस में it was held that Section 27 of Evidence Act is an exception to Section 24, 25 and 26. Next question. A witness who is unable to speak gives his evidence in writing in the open court. Evidence so given shall be deemed to be A. Oral evidence, B. Documentary evidence, C. Primary evidence, D. Secondary evidence. And the correct answer is A. It will be considered as an oral evidence because Section 119 of Evidence Act clearly says that evidence given by a dumb witness shall be deemed to be an oral evidence. कोई भी इंसान जो बोल नहीं सकता है, अगर वो अपना गवाही या कोई भी एविडेंस जो मुंह से बोलने वाला है वो अगर लिख के दे रहा है तो भी उसे अंडर सेक्शन 119 ओरल एविडेंस ही माना जाएगा. Next question. Any question suggesting the answer which the person putting it wishes or expects to receive is called A. Indecent question, B. Scandalous question, C. Question intended to annoy, D. Leading question. And the answer is D. It is said to be leading question and it is clearly defined in Section 141 of Indian Evidence Act. जो भी क्वेश्चन जो एक आंसर की तरफ राह दिखलाता है या ऐसे पूछा जाता है कि उसका आंसर प्रोमिनेंटली एक ही रहता है, उससे लीडिंग क्वेश्चन माना जाता है. लीडिंग क्वेश्चन A. May be asked in examination in chief, B. May be asked in cross-examination, C. May be asked in re-examination, or D. Cannot be asked in any circumstances. And the answer is B. Leading questions may be asked in cross-examination according to Section 143 of Indian Evidence Act. Next question. Which one of the following statements is correct? Admission can be oral only, B. Admission can be documentary only, C. Admissions can be oral or documentary, and D. Admissions are conclusive proof of the matters admitted. And the answer is C. Section 17 of Indian Evidence Act defines that admission It says that admission can be oral or documentary or in electric form. Next question. The facts, though not in issue, are so connected with the fact in issue as to form part of a same transactions are A. Relevant under the rule of res gestae, section 6, B. Not relevant, C. Hearsay evidence, D. Primary evidence. And the correct answer is A. Under Section 6 of Indian Evidence Act, the facts, though not in issue, are so connected with fact in issue as to form part of a same transaction are relevant under the rule of res gestae. Next question. Admissions and confessions are exception to hearsay evidence. Point to part of hearsay evidence. 3. Form relevant evidence. 4th. Admitted in evidence on proof. Select the correct answer by using the code given below. And the codes are A 1, 2 and 4, B 1, 3 and 4, C 1 and 2 and D 2. And the correct answer is B. Exception to the hearsay evidence, form relevant evidence, and admitted in evidence on proof. Next question. Under which section of CRPC Session Court exercises power of appeal from convictions? A. Section 372, B. Section 397, C. Section 374, D. Section 398. And the correct answer is C. Section 374, subclause 3 of CRPC. Next question. Under which section of CRPC an order form attachment of property of person absconding may be passed at any time after the issue of the proclamation? Section 83, B Section 82, C Section 84 and D Section 85. And the correct answer is A. Section 83. Next question. Under which section of CRPC provides for confirmation by the High Court of an order of death sentence passed by Sessions Court prior to its execution? A. Section 368, B. Section 366, C. Section 371, and D is Section 369. And the correct answer is B. Section 366. Next question. When the Sessions Judge or the High Court calls for to examine the record of any proceedings before any inferior criminal court, it is known as reference, B. Review, C. Revision, D. None of these. And the correct answer is C. Under Section 397 of CRPC, High Court or any session court may call for to examine the record of any proceedings before any inferior court. It is called revision. Next question. Which one of the following orders can be passed after the trial of a case is over? A. Only an order of acquittal. B. Only an order of conviction. C. Order of discharge. D. Either an order of acquittal or conviction. And the correct answer is D. Either an order of acquittal or conviction. It has a reference in section 235 of CRPC. Next question. First information report. A. Relates to cognizable or non-cognizable offense. B. Is given to a magistrate or police officer. C. Relates prima facie to a cognizable offense. And D. May be given to a district magistrate. And the answer is C. Relates to prima facie to a cognizable offense. Any person can give information to the police relating to the commission of a cognizable offense, and section 154 of the code provides for the manner in which the information is to be recorded. Next question. Under which section of the CRPC anticipatory bail may be granted to a person apprehending his arrest? Section A, Section 438, B, Section 439, C, Section 436, and D, Section 437. And the correct answer is A, Section 438. The provision regarding anticipatory bail is given under Section 438 of CRPC. Next question. Under the Constitution of India, all aspects of family law are in the A. Union list, B. State list, C. Concurrent list, D. None of these. And the correct answer is C. Concurrent list. Under Constitution Law of India, all aspects of family law are in the concurrent list, List 3, Entry 5. Next question. Assertion. The purpose of criminal law is to prevent crimes. Reason. In certain situations, even a private person can arrest another person. Code. Both A and R are true, and R is the correct explanation of A. B. Both A and R are true, but R is not the correct explanation of A. C. A is true, but R is false. And D. A is false, but R is true. And the correct answer is B. Both assertion, that is, the purpose of criminal law is to prevent crimes, and the reason, in certain situations, even a private person can arrest another person, are true, but reason is not the correct explanation of the assertion. Next question. An offense punishable with imprisonment for a term exceeding 2 years relates to a summons case, B. a warrant case, C. both of above, D. none of these. And the correct answer is B. An offense punishable with imprisonment for a term exceeding 2 years relates to a warrant case. Next question. Under which section of CRPC a police officer can arrest a person without an order from a magistrate and without warrant also? A. Section 42, B. Section 40, C. Section 51, D. Section 41. And the correct answer is D. Under Section 41 of CRPC, any police officer can arrest without an order from a magistrate and without warrant in a cognizable offense only. Next question. Under which section of CRPC a person who is avoiding execution of a warrant may be proclaimed absconder? Under Section 81, B. Section 83, C. Section 82, or D. Section 84. And the correct answer is C. Section 82. This section is regarding the proclamation of a person absconding. Now let's see our two last questions, that is question number 49 and question number 50. So question number 49 is, under which section of CRPC an accused person can himself be a competent witness? Under section 315, B under section 300, C under section 313, and D under section 317. And the correct answer is A. Under section 315, an accused person can himself be a competent witness. And here comes our last question. Who among the following is authorized to record a confessional statement under section 164 CRPC? A. A police officer, B. An executive magistrate, C. A judicial magistrate, D. Neither an executive nor a judicial magistrate. And the correct answer is C. A judicial magistrate is always authorized to record a confessional statement under section 164 of CRPC.